Hello everyone and welcome to yet another video which is about same-sex marriage in India and the recent debate around it. This topic is very much relevant because it has been in news in the recent past. It is relevant for various point of view that how the new institution and definition of marriage is coming up in India, how what about it can also come as a right to the queer community in India, and how what is the next step after the decriminalization of Article 377 in India. So in different ways this article or this particular topic can come to your examination. So let us discuss about it and what is the recent debate around this particular topic. So let us first understand what do we mean by the same-sex marriage. The same-sex marriage as a term is quite clear that it's about marriage between two people from same sex or same sexualities, which are largely put into the category of LGBTQAI plus in India. Before we get into this debate of marriage between the people of these community, and which are largely defined as same-sex couples, what do we mean by LGBTQAI plus people in India? The full form would be lesbian, gay, bisexual, transgender, queer, intersex, asexuals, and other. They are the people who do not identify with heterosexual ideals. Heterosexual ideal means where the society is divided between men and women and the sexual relations within these two only. So basically, the queer or the LGBTQA would be challenging this understanding of defining or practicing sexual relationship. It largely relates to the homosexuality. All right. So it also includes specific social group, a distinct community, which are called the Hijras, and known as the third gender in the Indian society. So they are considered to be neither men nor women, or nor as sometimes as men who behave like women. So they're considered as third gender. So all these category of people, they would come as those people who do not identify with cisgender heterosexual ideals. Okay. Now let's see the little bit of history about LGBTQA plus people, and we have to recognize this plus is very important because this plus signifies that there are many more identities than written here. Plus means there are many more to come. And that is why we have to keep in mind the whole idea, the whole idea of same-sex marriage, the whole debate of same-sex marriage, by keeping this plus in mind. I'll come to that later. So the history of LGBTQA community, or let's say the homosexuality in India, is quite old. The ancient and medieval text have various instances of homosexual relation. In medieval time, many emperors like Khalji and many Mughal emperors were considered to be homosexual in their sexual orientation. In the ancient time, or in the Indian mythology also, we do find certain mythological characters which are considered to be homosexual in their sexual orientation. So, which means what? That in the history of India, homosexuality was not a crime. Okay. Then how it became criminal? How it became a crime? So, with the more modern categorization of sexes, which was initiated in 19th century Europe, and it came to India under colonial rule. Okay. And because of that, the criminalization of homosexuality happened in India. So during British rule in 1860, homosexual intercourse was considered unnatural and was declared a criminal offense under Chapter 16 of Article 77 of the Indian Penal Code (IPC). You must have come across this section, Article 3, Section 377, but the meaning of that was that it criminalizes the homosexual relations in India. When in September 2018, the Supreme Court ruled unanimously lifted declared Article 377 as unconstitutional. That means what? That means after that, it was decriminalized. It was not a crime anymore to have homosexual relations between adults of the sexual relation between adults of same sex. So India has traveled or covered the journey of having recognition to homosexual relations in the ancient and medieval time. By the time we come to modern Indian history, we find that there is a criminalization of homosexuality in India. But in the second decade of the 21st century, in 2018, the Supreme Court decriminalized the homosexuality in India, and it is now a legal sexual orientation to have a same-sex relationship. So how this whole debate started? This whole debate started about, now we come back to the same-sex marriage and why after decriminalizing 377 and after having recognition of the same-sex relationship in India, why the debate and how the debate started about the same-sex marriage. It started with two petitions. First, it was filed by a couple who have been, staying together for a decade, and the second who was staying together for 17 years, and they were raising children together also. Maybe adopted children, and but the state did not recognize their marital status. So they could not have legal relationship with their children. They were raising children, but they could not have legal relationship with their children. What is the problem that you see here? What the children will not have, the terminology of mother and father, and the marriage will not have a terminology of husband and wife. Okay, so these were the major arguments that were used against legalizing same-sex marriage by the Supreme Court. There were other petitions also which were talking that, why don't we put same-sex marriage under the Special Marriage Act of 1954? And against that, what was said that we cannot put same-sex marriage under Special Marriage Act of 1954 because it is not about creating new institution of marriage. The Special Marriage Act, if you see here, the Special Marriage Act is not about having new institutions of marriage, but it is about giving marital recognition of those people who do not want to register marriage under any religious, personal law. So Hindu will register their marriage under Hindu personal law or Hindu Marriage Act. Muslims and Parsis and Christians, they will register their marriage in their respective religious personal law. But there can be many couples who, in which one of them do not belong to the same, they don't belong to the same religious community, and to take care or to recognize marriages among those people, the Special Marriage Act of 1954 came up. It allows people from two different religious backgrounds to come together in the bond of marriage. Okay. It lays down the procedure for both solemnization and registration of marriage where either the husband or wife both are not Hindu, Buddhist, Jain or Sikh. What this act does, it plays a key role in liberating individual from the traditional requirement of marriage. Traditional requirement of marriage used to be, it should be endogamous in terms of their religious background. But now the liberating in this act liberates people that even if people are marrying out of their religious identity, then this act takes care of the registration of that marriage. But it cannot or introduce new forms of marriage. Why same-sex marriage will lead to new forms of marriage? Because it will have to redefine the meaning of wife and husband, and the term of wife and husband were either supposed to remove from the marriage or has to be rethought. And this will definitely bring new forms of marriage for which the Supreme Court cannot make any, and it cannot be put under the Special Marriage Act. So what happened to this whole debate of Special Marriage Act, sorry, same-sex marriage, or to be put it under Special Marriage Act? So in the proceedings, when the hearing, started in the Supreme Court, during the proceeding, it was finally deferred to the Parliament, because and it was stated that law cannot be revised to permit same-sex marriage again, because for that we need to redefine the institution of marriage, and of course various laws around that, laws around marriage, which needs certain constitutional changes, and Supreme Court cannot do that, so it forwarded to the Parliament. So what were the argument given against the same-sex marriage during the whole debate that happened in the Supreme Court for the discussion of same-sex marriage? Let's look at that. So marriage has, it actually attacks, one of the argument was that it actually attacks a religious definition of marriage. So marriage has traditionally been between a man and a woman in many religions. Special Marriage Act was created to overcome the religious limitation of religious personal laws and not to create new institution of marriage, as I just said. So it goes beyond the marriage in which there is a man and a woman. Another thing is that the state has a legitimate interest to regulating marriage and personal relationship as seen in the laws regarding age of consent, prohibited degrees of marriage and divorce. So when a marriage happens, the state also need to take care of whether the age of consent of this marriage is fine, whether the divorce rights or the marriage, other rights pertaining to marriage, such as inheritance or claim on property, whether all these things are also being taken care. Here in same-sex marriage, how the state will take care of that, where the term of husband and wife is not clear. Another argument that was given in the court, that it should be legalized. The same-sex marriage should be legalized under the right to privacy. In 2017, the Supreme Court recognized the right to privacy as a fundamental right. Again, it was stated that the sexual orientation is somebody's personal or very private private aspect of somebody's identity, and the state should protect it. But however, privacy exists, but it cannot be extended to marriage. Sexual orientation can be private, but marriage cannot be private, because marriage leads to various other dimensions or many changes, or it touches many other dimensions of the society. First of all, primarily it touches the dimension of legal rights. It touches the dimension of children, and how relationship between adults, and this does not, it makes marriage beyond the private or the right to privacy. So only Parliament has the authority to decide on same-sex marriage, as it is a matter of democratic right, and courts should not legislate on the issue. That was a final decision that was given by the Supreme Court. There could be potential unintended consequences in law, and the complexity of dealing with the various permutation and combination of gender falling under the LGBTQAIA plus. As I said, that there are many permutation and combination of LGBTQAI community people, which has 72 categories. So when you have many other categories of sexual identity or gender identity, how will you bring those different category of people and their rights and their recognition under the same-sex marriage act or same-sex marriage debate? It's not possible. So that is why it is said that we do not know many, or there are many other gender identity, and for this, and we cannot bring such a vast changes in the institution of marriage. So the Special Marriage Act cannot be interpreted to include same-sex marriage because the act entire architecture would need to be examined, not just a few words. For example, Act provides specific right to a wife, as I said, and it's unclear who would have these rights in the same-sex marriage. Additionally, allowing one party in a same-sex marriage to have a specific right could create a problem for heterosexual marriages. Okay. Another example. Law provides specific right to a wife. Try to understand it from this point of view. Specific right to a wife is given by the law under the institution of marriage. So the law says that a wife acquires the domicile of the husband upon marriage. So who will be the wife in the same-sex marriage? That is a big question. Another related question, who is the husband in the same-sex marriage? Whom to blame if domestic violence happens, and how we are going to, so this unclarity of identity of husband and wife cannot lead to same-sex marriage approval or acceptance in the Indian social and legal system. Issue of divorce, how we will tackle that? How the maintenance or other it also provides, as of now, the law related to marriage provides right to wife to take divorce on the ground of if the husband is guilty of rape, sodomy, and bestialities. But if the husband and the wife and identity is not clear, how this whole discussion on divorce and the ground of divorce would be exercised. So this brings a problem. Another bigger problem, issue of adoption of children. So when next step of marriage is what? Is to have children. So when children will come into the picture, and that will come largely through adoption. When they grow up, they will grow up under the social societal stigma and discrimination that they belong to a couple who is of same sex. Is our society ready to accept such children? And negative impact on the child's emotional and psychological well-being is expected. Is it essential to have such pool of children who are brought up into the environment of societal stigma and discrimination? And that is also an argument that went against the same-sex marriage. So argument that gender terms like mother and father, husband and wife would be problematic in same-sex marriage. So these were the arguments, those were given for the against the same-sex marriage in India in the recent debate. It was early 2023 when this whole debate started, and now it has been given to Parliament, and only Parliament can take care of this. Supreme Court cannot. Cohabitation can be a fundamental right. If two people want to stay together, that is okay. And when Article 377 has been decriminalized, people of two similar sexual orientation can also stay together. But you do not ask for the marriage, the stamp of marriage on that cohabitation as a fundamental right. That state cannot provide. That the court cannot provide. So the justice suggested that recognition is needed for such relationship to receive certain benefits, but not necessarily as marriage. You can recognize these relations for other benefits, such as you can or there's another very important point that was suggested by the court, that we can use the label such as contract or partnership, but not marriage, instead of marriage. And the government said that there is no fundamental right to seek recognition of same-sex marriage, same-sex relationship as marriage. So you have to be clear that right to privacy is fine. Right to cohabitation is a fundamental right is fine. But same-sex marriage is a fundamental right. Same-sex marriage is a right to privacy is not fine, because cohabitation and right to privacy is in the private domain, but marriage makes it a public domain for various reasons, which we just discussed. So marriage cannot be recognized as fundamental right among same-sex couple. So another argument given by the Chief Justice of India, that needs to be assimilated in the same-sex couple into society. It's important that they are assimilated into the society rather than we ostracize them. And Article 377 was a very important step in that. But the government should address the practical issues faced by same-sex couples, such as joint bank account. We can address these issues. Entitlement of pension and gratuity, we can address these issues also. But issues pertaining to marriage, we have to also see whether the Indian culture and value system are ready for that, and whether it goes against the traditional value and belief of the Indian society. However, the recognition of same-sex marriage adds to the diversity of relationship that exists in the society. That was also mentioned. So given all these points that went against the same-sex marriage, Supreme Court has deferred the case to Parliament on the matter, stating that the law cannot be revised to permit same-sex marriage again. Why? Because you have to keep that in mind. The definition of wife and husband is not clear. The for children, the understanding of mother, or who will be the mother, who will be the father, that is also not clear. And what else is so? Because of all these issues, and if you remove these term wife and husband from the institution of marriage, then various other laws in which this term is used for the right of the woman in the marriage, or where these terms are used for women empowerment, there has to be you need to bring changes in those laws also, which is not possible because there are many laws in which these nomenclatures are used. A right to maintenance, divorce, succession, property, and residential rights, children custody right. How will all that will be dealt with when we have no clarity in the nomenclature of these designations, or these nomenclature in the understanding of marriage. Another issue that I want to bring here, and also is part of the recent debate in India, is the polygamy in India. Polygamy, before getting into the recent debate, let's understand why it came to forefront. It was brought into the forefront by the Chief Minister of Assam, in which and he said that he really wants to ban the practice of polygamy in the especially in the region in and around Assam. And so what is polygamy? Polygamy words come from poly, which means many, and gamos, which means marriage. So somebody who is having Many marriages or more than one marriage is called a polygamous marriage. So thus a polygamy marriage is in which a spouse of either sex may have more than one mate at the same time. So traditionally, polygamy was widely practiced in India, but the Hindu Marriage Act of 1955 banned it. Again, why it was banned? It was banned for the idea of women empowerment. So the status of women in the marriage increases. So that women are not, ostracized, and they are not ostracized, or they are not neglected, ignored, or left in the name of polygamous marriages. The status of wife remained intact. So that is why Hindu Marriage Act of 1955 outlawed the practice of Special Marriage Act, the practice of polygamy. The Special Marriage Act allowed individuals to perform interreligious marriage, but it also forbids polygamy. Polygamy is not allowed. So, let's have an understanding of what is polygamy, how the polygamy is understood. Polygamy can be understood as polygyny. Polygyny means where you have one male having numerous wives. Then comes polyandry, where there is one female and having several husbands. Bigamy is when one is already married, and in addition to the marriage, he has one more marriage. Okay, that is bigamy, and that's how these all marriages come under polygamous marriage. So polygamy, the practice of having more than one spouse, is illegal in India under the Indian Penal Code. But Muslim men are allowed to have up to 4 wives under Sharia Islamic law, and polygamy also exists in many tribal communities. So the central government wants to impose, and that is why, because there are different laws pertaining to the polygamy or monogamy marriages in different religious groups. So the central government, that is why, is determined to bring uniform civil code here, and so that all people of India, everybody in India is uniform, has all similar kind of legal rights vis-a-vis marriage, divorce, inheritance, and adoption is concerned. What is Uniform Civil Code? UCC. UCC is what? Article 44. Remember that. It will be important for polity and for social issues, both. So Article 44 corresponds directive principle of the state policy, stating that state shall endeavor to provide for its citizens the uniform civil code throughout the territory of India. What is uniform civil code? Uniform civil code means all sections of the society, irrespective of their religion, shall be treated equally according to the national civil code, which shall be applicable to all uniformity. So, Muslims are ruled by their personal laws, Christians are ruled by their personal laws, and Hindus are ruled by their personal laws. Parsis are ruled by their personal laws. So this is bringing different rights of men and women in the institution of marriage, or the issues of divorce, marriage, inheritance, and adoption. These different forms of rights are not needed if we bring uniform civil code. That is the main argument. These issues should not be driven by the religious personal laws. So, and the uniform civil code will remain important because it was there in the mind of prominent leaders who were drafting the Constitution of India, like Jawaharlal Nehru and B.R. Ambedkar. They pushed for uniform civil code. However, they included UCC in the directive principle of the state policy, mainly due to the opposition from the religious and fundamentalists and lack of awareness among masses during that time. So, with this, I bring to your notice and you have to remember in mind that polygamy not allowed in India and same-sex marriage not allowed in India. All right, and these two topics can be relevant for the discussion on the issue of marriage or changes in marriage in India. Keep that in mind and prepare this question, because there might be coming in your GS paper, because especially the same-sex marriage topic, because it is a very hot and recent topic, and we just had a debate around this topic in Supreme Court, and it has gone to the Parliament now. With this, I take your leave and see you in some another video very, very soon. Take care. Bye-bye.